The legal research subject has a key focus on law reform. And this is an issue which is extremely important for law students, and it's one we don't talk about enough. Now, as I've mentioned in a previous video, one of the reasons we look at law reform in a very, very practical way in legal research is that it touches on all the different skills and all the different sorts of research sources that we're going to need as a legal researcher. But there's more to it than that. And this is something that I thought it's worth spending a couple of minutes talking about to establish what law reform is and why it's important. So law reform is the process of improvement for legal systems that's conducted by government with the engagement of the public, and particularly engagement through public organisations. There aren't that many people who individually engage in law reform in most issues. Generally, it's organisations that lobby on behalf of individuals. And that's a system of democracy, or a modified system of democracy that we call pluralism. And it's a key function of the executive government, and it's a key part of rule of law, that if we're all bound by the same law, then we all have a responsibility to make sure that law works as well as it can. And it's particularly important for legal practitioners, as the custodians of the law, to be involved as part of that process, as being responsible for the law. And when we think about pro bono work, we do tend to think about representing clients. But this is another aspect of pro bono work which is just as, possibly more important. It's making the system work better, so hopefully clients aren't going to fall afoul of the legal system and aren't going to necessarily need the same sort of help. And it's something that's important for all lawyers, and particularly for law students. It's never too early to start. It's something you can get involved in right now, while you're a student, and it's something that's a good thing to be involved in throughout your professional life. And you'll notice that many community legal centres are also involved in the law reform process, and quite often they, because their resources are stretched so thin, will require volunteers to help them prepare submissions to these public reports. So law reform begins with a terms of reference created by an Attorney General, and they hand it over generally to a law reform commission, which is a standing body. It's a commission of inquiry that has continual life, and it has all the powers of a commission of inquiry, but its job is to answer these particular law reform issues. Now, that's not necessarily the case. There can be a new commission of inquiry created for a particular issue if it's a particularly big one. Something like the Fitzgerald inquiry, that was a completely new inquiry that was created rather than go through a law reform body. Although I don't think Queensland had a law reform body at that stage. But today the Commonwealth and all the states have these law reform bodies. So the Attorney General creates terms of reference, and then the Law Reform Commission creates an issues paper with all the important issues in there, sends it out to the public, and asks for public submissions, asks for public contributions to the process and opinions. And this is where we come in, because we have access, and it's really an early form of crowdsourcing when I think about it, of being able to say, as a government, we don't have access to all this information. Please, members of the public, can you fill us in on what you think about these and add any additional information? At the end of the day, the Law Reform Commission then makes a report that recommends changes to the government, and then the government does what it wants. But it's a strong, persuasive document along the way. And a government that ignores the recommendation of a Law Reform Commission does so at its peril, because it can be politically volatile. And when we're talking about law reform, it's also important to remember that it's not necessarily about change. It can be about resisting change. You can believe that the legal system is being compromised by proposed changes, and you can argue that we need to keep things the same way. Yes, people need to have the right to trial by jury. We need to protect people's rights. So law reform is not necessarily just about going out and changing things. Sometimes as lawyers, we need to say, hang on, we need to protect the things that matter, because governments don't always do that. I know that's probably going to be a shock to you, but governments don't always act in the best interests of people. So law reform is an important counterbalance to be able to resist that. All right, so as I mentioned earlier, this is useful to your students because it covers all sorts of sources. It covers legislation, regulations, Hansard cases, media reports, academic research, policy papers, statistical research. All the different things that we're going to look at generally go into a law reform process. But it's also useful, I think, to think about this as a career path. That is something that is very seldom spoken about in most law programs. We talk about the divergence of different law careers, but we do tend to think about working in a law firm or working as a barrister, whereas there's a long-standing tradition of working as in law reform, and it was certainly something that I wasn't aware of myself. And my personal start as a lawyer was in the law reform area, and it was quite a surprise to me. So please don't have that as a surprise for you as well. That there is a lot of work to be done, not just in government, but also in organisations who need to make all these submissions and have to be able to represent their point of view and their perspective to the law reform process. And finally, it's also an area, I think, that is under-resourced and underappreciated, where the work that you will do as a student and the research that you will submit is going to be very valuable. These organisations have budgets, they have limited time frames, they have a lot of work to get through. And as someone who has worked inside a commission of inquiry, having a well-researched, well-thought-out, well-argued submission from a student is wonderful. It saves you a lot of time, it's extremely useful, and it certainly provides, I think, a stronger set of resources for the Commission than a well-intentioned but not well-informed argument from a general member of the public. Those you can say, well, okay, this particular person, they like it or they don't like it, but there's not really much you can generally do with it. But something that's a well-reasoned, well-organised, well-researched submission from a student, that's something you can actually work with. Now, everyone who puts in a submission to a law reform body through a law reform process gets acknowledged in the final product, and if you do really well, you'll be cited in the document itself. And these are all good things for your portfolio and your career personally as well. But ultimately, I want to come back to the point of this being something that's an important part of your service as a lawyer as well, and it's something that as lawyers, the law is something that we're responsible for. It may not always feel like that. It may feel like often that it's something that's out of our control, but it's something that we need to make the effort, and we need to get engaged, and we need to be the ones who are making the sensible, logical, well-informed, well-researched submissions. Otherwise, the public opinion may go in a direction which is not one which is consistent with rule of law, and is not one that we want to see as legal professionals. Okay, so that's a very quick introduction to law reform and why, as a student, you should really care about it.